Um, Thank you, Acting President, and I'm pleased to rise to the Judicial Proceedings Reports Amendment Bill, just as I was pleased to speak on it last year as well. This, as Mr O'Donoghue mentioned, is the second or third time round for this legislation and for this bill. And the background, as we know, is that the unintended consequences of the last well-meaning piece of legislation that was designed to protect victims inadvertently silenced victims who wanted to speak out and tell their stories. So we fixed that, but now we're talking about those victims, the families of victims who incredibly sadly have lost loved ones to sex offending crimes. And certainly what's very sharp in my mind right now is that John Heron, the father of Courtney Heron, appeared before the Justice Inquiry yesterday and spoke about the death of his daughter. And I think certainly him wanting to speak out is really important for him. But that's not always the case. But last year we clarified, the unintended consequences for living victims of sexual assault, and really gave them the choice, and it gave them the ability to control their own narratives, to tell their own stories without barriers, or not, if that was what they wanted. So it became harder it became harder when it comes to deceased victims, because sadly they're not here to make that choice. They're no longer able to control their own story. And that was the complex issue that we're dealing with today. And I think, certainly as far as I have heard from stakeholders, they have been quite pleased with the consultation that the government has conducted over the last 6 months. This bill will allow the publications of details that identify a deceased person as a victim of sexual offending. It also introduces a victim privacy order scheme, which will allow persons close to the deceased sexual offence victim to apply for a court order to restrict or prohibit the publication of details that would identify their loved one. So in effect, this reverses the presumption that was built into the legislation that we passed last year, and it supersedes it. And I think, I actually, unlike Mr O'Donoghue, I would actually kind of commend the government for recognising that they'd made an error, and for listening to those campaigners, listening to the Let Us Speak campaign, listening to those advocates like Nicole Lee, like Nina Fennell. In fact, sometimes I wish this happened more, that we acknowledge that we didn't necessarily get it perfectly correct, and we go back and talk about it, and we come back and we keep talking to the community, we keep consulting, and in that way we create better legislation. But in saying that, I think there's one aspect of this reform that troubles me, and I note Mr O'Donoghue has got a similar amendment. There's many things about the criminal justice system that trouble me, but this section in this bill is something that that I will seek to amend. Actually, could I get my amendment circulated, please, Acting President?
Thank you. Can we have the amendment circulated? Thank you.
Thank you, Acting President. Look, as it stands, when this bill passes, the victim privacy orders are good. They're a good thing. They protect that small cohort of deceased victims, families, who want to maintain their privacy in relation to sexual assault cases. But the ability to expand the scheme via regulation without parliamentary oversight could theoretically apply this scheme to an infinite number of criminal offences, even alleged or proven. And there's a pretty low threshold, that being undue distress. All of this could be done, this expansion of these effectively victim privacy orders, all of this could be done with just by regulation. It would not have to come back to the Parliament. So to expand these types of effectively suppression orders could be expanded to many other crimes, to many other circumstances, without any debate in this chamber. And while I was grateful, and I thank the Attorney-General for corresponding with me on this issue, and I have no reason to doubt that she has no intention of using this power unduly or unfairly. But what happens in the future? We don't know what will happen in the future. And I think the checks and balances of the Parliament for something as important as this is important and is crucial. Who knows who could be the next Attorney-General? Maybe Mr O'Donoghue, but who knows who it could be? And so I think the idea to leave the door ajar for the suppression of independent free press. We could even, these types of privacy orders could be manipulated in many different ways. So I think what our proposition here today and via our amendment is to simply remove the regulation-making powers. I note, as I said, that Mr O'Donoghue has moved amendments to the same effect. So I think it's a sensible change that I would hope the majority of the House can support. Apart from that, I fully support this bill, and I hope that it does bring small comfort to the families that it affects. And I'd just like to make on a final note that those victims of other crimes that this bill does not extend to, I would hope that we can talk about that in future, and we can talk about how we might amend legislation going forward. But I believe that it should be amended via the Parliament, not via regulation. Thank you.